The Nationality Law of the People's Republic of China regulates nationality of the People's Republic of China. Chinese nationality is usually obtained either by birth when at least one parent is of Chinese nationality or by naturalization. The Constitution of the People's Republic of China states that all persons holding nationality of the People's Republic of China are citizens of the People's Republic of China. Although in practice, the citizenship of Mainland China is the hukou, while the two SARs, Hong Kong and Macau, each has their own rules on the rights of abode in these territories. In theory, the Chinese nationality law is de jure applicable to Chinese nationals residing in all three constituents of the People's Republic of China, namely Mainland China, Hong Kong SAR, and Macau SAR. Due to the complex history of Hong Kong and Macau SARs, however, special explanations of the nationality law were made in place by the National People's Congress before the handover of Hong Kong and Macau. These interpretations, applicable only to permanent residents of Hong Kong and Macau, have created a separate class of Chinese nationality unique to those two SARs, which differs vastly, especially with the acquisition and loss of nationality, from the Chinese nationality of Mainland Chinese residents with hukou. The law was adopted at the third session of the 5th National People's Congress and promulgated by Order No. 8 of the Chairman of the Standing Committee of the National People's Congress and effective as of September 10, 1980. History. Prior to the Communist government's establishment in 1949, the Republic of China's nationality law, enacted in 1929, served as the basis for Chinese nationality for Chinese residing in China mainland. ROC's 1929 nationality law was in force only in Taiwan after 1949 when the Kuomintang government lost the Civil War, until it was revised in 2000, for the establishment of the communist regime on 1 October 1949 to 9 September 1980. The PRC has no statutory nationality law except for the Sino-Indonesian Dual Nationality Treaty adopted in 1955, which was a bilateral treaty between the PRC and Indonesia's Sukarno government instead of a statutory law. For the period between 1949 and 1955, the PRC recognized dual nationality as to the ROC. Therefore, the treaty was the first regulation in Chinese history to ban dual nationality between China and other countries. On 10 September 1980, PRC's current and only statutory nationality law went into effect. The law itself, however, has been criticized for being outdated, as many countries have amended the nationality laws to allow dual nationality since 1990s, and the opinions on whether China should fully permit dual nationality has constantly resulted in heated debates. It is worth noting that dual nationality is still possible under the current nationality law. Nationality by birth. Chinese nationality law operates mainly on the basis of jus sanguinis, although a different type of jus solely applies to any person of Chinese descent who were born in Hong Kong and Macau. On 1 October 1949, most nationals of the Republic of China remaining in China mainland were recognized as nationals of the People's Republic. Birth within Mainland China, Hong Kong and Macau. According to the nationality law, a person can acquire a Chinese nationality by birth in China if he or she meets one of the following requirements. At least one of his or her parents has Chinese nationality. Both parents are settled in China, who are either stateless, or the nationalities cannot be determined. The term "settled" is not further defined, and it's unclear whether this term in this particular concept has the same meaning with the same term in other concepts. Children born of Chinese foreign marriages on territories controlled by People's Republic of China are considered to be Chinese nationals by the government of the People's Republic of China, as per Article 4 of the Chinese Nationality Law. This can create problems when the Chinese national parent gives birth to, or fathers, a child with a non-Chinese national parent in mainland China without the prior approval from the National Population and Family Planning Commission. In this case, the child is not eligible for Chinese hukou and subsequently cannot qualify for a Chinese passport. Furthermore, the child's foreign citizenship acquired through jus sanguinis is not recognized by Chinese authorities as per Article 3 of Chinese Nationality Law, so he cannot use the non-Chinese passport to exit the country. As a result, the child's parents must secure an exit entry permit from the Chinese government in order for the child to exit and re-enter mainland China. However, this restriction does not apply when the Chinese parent is a permanent resident of Hong Kong and Macau. Birth in Hong Kong and Macau to parents of Chinese descent. An alternate form of jus solely applies to any persons of Chinese descent who were born in Hong Kong and Macau. The explanations of some questions by the Standing Committee of the National People's Congress concerning the implementation of the Nationality Law of the People's Republic of China in the Hong Kong Special Administrative Region, a supplement Nationality Law document applicable only to Hong Kong residents, states that any Hong Kong resident who is of Chinese descent and was born in the Chinese territories before or after the handover is a Chinese national with right of abode in Hong Kong. Same provision with exact same wordings also exists in the explanations of some questions by the Standing Committee of the National People's Congress concerning the implementation of the Nationality Law of the People's Republic of China in the Macau Special Administrative Region, its equivalent of Macau. In practice, many overseas Chinese who are of Chinese descent are not Chinese nationals, so this provision effectively bestowed Chinese nationality on any child who is of Chinese descent and was born in Hong Kong and Macau regardless of the nationalities of his parents, in addition to the right of abode in Hong Kong and Macau. In 2014, a Hong Kong permanent resident who was born in Hong Kong to an ethnic Chinese father and a mother with Belgian citizenship before the handover lost his Belgian citizenship he acquired through jus sanguinis, because of a clause in the Belgian nationality law which requires Belgians born outside Belgium with multiple citizenship to declare the intention to retain the Belgian citizenship. The Belgian Consulate General used the clause from the explanations to state that the person does hold Chinese nationality after the handover, through his birth to a Chinese descent father in Hong Kong, and thus he held Chinese nationality in addition to his Belgian citizenship before it was lost. The person has never held any proof of Chinese nationality, including a HKSAR passport, a BN passport, or a home return permit, except for his British-issued Hong Kong birth certificate, which the Belgians deemed as sufficient to prove his Chinese nationality. Birth abroad to Chinese nationals. Chinese nationality law states that a person born abroad is a Chinese national through jus sanguinis if the person is born outside China with at least one parent who has Chinese nationality, and the parent with Chinese nationality has not yet settled in a foreign country, or the person is not eligible for the nationality or citizenship of the birth country, regardless of the parent's immigration status in that country. The term settled is usually taken to mean that the Chinese national parent has permanent residency in another country. Article 5 also states that a person born outside China to parent with Chinese nationality does not have Chinese nationality if a foreign nationality is acquired at birth and one of the Chinese national parents has gained that country's permanent residency. An example involving nationality by birth in solely countries, including the U.S., would be that if a child was born in the United States by two Chinese national parents, and one of them has already acquired U.S. permanent residency, but the other one has only temporary status in the U.S., then the child is not a Chinese national at birth since one of his parents has settled abroad and he acquired a foreign country's citizenship at birth. However, if the parent with permanent residency had completed the naturalization process as a U.S. citizen prior to the child's birth, then the child acquires Chinese nationality at birth, since his or her other parent has not settled abroad and is a Chinese national. However, a child who was born in U.S. to two Chinese parents is ineligible for U.S. citizenship if one parent was a Chinese diplomat, as the U.S. does not grant birthright citizenship to any person with a parent that are employed in diplomatic or official capacity of a foreign state, even when the other parent is a green card holder. Therefore, the child is solely a Chinese national in this particular case, although it is possible for him/her to become a U.S. permanent resident by obtaining a green card. The jus sanguinis part of the Chinese nationality law applies to all Chinese nationals without discretion, including those who are Hong Kong and Macau residents. Therefore, the situation mentioned above also applies when the parents are PRs of Hong Kong and Macau. Naturalization. A person can apply for naturalization as a Chinese national if he or she meets one of the following criteria: is a near relative of Chinese nationals, has settled in China, or has other legitimate reasons. Despite not explicitly expressed in the nationality law, naturalizing as a Chinese national requires the applicant to be a permanent resident in either three constituencies of China. Once naturalized, the person's residency of mainland China, Hong Kong and Macau will remain unchanged, although naturalizing in mainland China will also result in the acquisition of hukou. Each constituency have different additional requirements for naturalization. All persons who naturalize in China, including Hong Kong and Macau, cannot retain the foreign nationalities, so they must renounce all the foreign nationalities either during or after naturalization. In case of Hong Kong, foreign nationalities must be renounced as a part of naturalization process, while in Macau all applicants have 6 months to renounce foreign nationalities upon a successful naturalization. Mainland China also requires the renunciation to be made as a part of application process. The Chinese People's Congress have granted the powers to naturalize non-Chinese nationals to governments of Hong Kong and Macau SARs. So the naturalization process in these two territories is different than the process in mainland China. In Hong Kong, the Immigration Department is responsible for naturalization applications, and its equivalent in Macau, Direcção dos Serviços Identificação, is responsible for applications filed in Macau. The ultimate decisions are made by the officials in either departments. In mainland China, one must file an application to the subdivisions of Ministry of Public Security. Naturalizing as a Chinese national is rare. During the 5th National Population Census of the People's Republic of China, only 941 naturalized citizens not belonging to any of China's recognized 56 indigenous ethnic groups were counted in China's mainland. More foreigners have applied for naturalization as Chinese nationals with permanent residency of Hong Kong since the handover in 1997. Among Hong Kong residents from 1997 to 2012, 3,411 Pakistanis, 3,399 Indonesians, 2,487 Indians, 1,115 Vietnamese, and 387 Filipinos have been naturalized. One case of mass naturalization occurred in 2003, when less than 200 Damans, an ethnic Nepali people who had resided in Jarong County of Tibet for over 2 centuries, were granted Chinese nationality. The serial numbers on the naturalization certificates suggested that around 4,000 people have naturalized as Chinese nationals in mainland China. Until 2003, it is worth noting that the naturalization process does not apply to nationals of the Republic of China, since the ROC nationality is already considered as Chinese nationality by officials in all 3 constituencies. Cost for naturalization. The cost for naturalization differs between the 3 regions. In mainland China, the application cost is 50 Chinese yuan and the certificate of nationality costs 200 Chinese yuan. In Hong Kong, the total cost is $3,460, composing of an initial application fee of $1,730 and the remaining fee of $1,730. In Macau, the cost for application is 1,000 Macanese patakas for the main applicant and 500 Macanese patakas per family member, plus a fee of 200 Macanese patakas for each certificate. Special naturalization process for Macanese people. Due to the complex history of the Macanese people, a group of mixed-race people with Chinese and Portuguese ancestry and the residential ties with Macau, the DSI allows a special naturalization process known as selection of Chinese nationality. The applicant must prove he or she has Chinese ancestry in addition to Portuguese ancestry. Renunciation of Portuguese nationality, however, is not required, so the applicant will usually have dual nationality after the selection. The cost is 200 Macanese patakas for main applicant and 100 Macanese patakas for each additional family member, plus a certificate fee of 150 Macanese patakas per person. Lost, termination and renunciation of nationality. Loss and termination of Chinese nationality. Chinese nationality is automatically lost when a person has settled abroad and pursues one of the following acts: naturalizes as a citizen of another country, or voluntarily acquires the nationality of another country. The term settled has the same definition as above. Outside the circumstances of legally automatic loss of Chinese nationality under Article 9, Article 10 provides for voluntary termination of Chinese nationality under certain circumstances, discussed further below. For example, a Chinese national who possesses Canadian permanent residence status and who naturalizes as a Canadian citizen loses his Chinese nationality upon the completion of his naturalization because he has voluntarily acquired Canadian citizenship while settled abroad. And any minor children under the age of 18 he might have also loses Chinese citizenship if the children have naturalized as Canadians along with the parent, regardless of whether the children's acquisition of Canadian citizenship is against the will. Article 9 is only applicable to Chinese nationals who acquire foreign citizenship while settled in a foreign country. On the basis of the treaties relating to the return of Macau and Hong Kong to China and the basic laws of the territories, the National People's Congress has issued interpretations of the nationality law that deem Hong Kong and Macau, whether before or after the return to China, not to be foreign territory. As a result, residents of Hong Kong and Macau who would normally be deemed to be Chinese nationals are not deemed to be settled in a foreign country. and so do not lose the Chinese citizenship by virtue of acquiring foreign nationality, whether before or after the return of those territories to China, even if they are recognized as the national of the foreign country under the country's laws. The dual citizenship is not recognized by China under Article 12 of the Nationality Law, except for a limited administrative exemption permitting such persons to travel to and from Hong Kong and Macau respectively using the relevant foreign countries' travel documents. As a result, Hong Kong and Macau residents can only satisfy the requirements of Article 9 if they acquire foreign nationality after becoming settled abroad. Alternatively, they can apply to renounce Chinese nationality by virtue of Article 10 of the Nationality Law. This special arrangement applies to Hong Kong and Macau residents. It does not affect the operation of Article 9 in respect of former residents who have become settled in another country and acquire foreign citizenship, as such persons have become settled in a foreign country at the time of legally automatic loss of Chinese citizenship under Article 9. If they return to reside in Hong Kong and Macau, they can notify the acquisition of new nationalities to the respective governments, upon which they will be recognized as foreign, rather than Chinese, citizens. See further discussion of Hong Kong and Macau specifically below. There is no provision in Chinese nationality law regarding the involuntary acquisition of another country's nationality can cause the loss of Chinese nationality. An example would be a Chinese woman marries a man from a country observing jus matrimonii, in which case she automatically becomes an Iranian national upon marriage. Also, Article 9 explicitly states that only Chinese nationals residing abroad who voluntarily acquires another country's citizenship shall be deemed as forfeiture of Chinese nationality. As a result, a Chinese national residing in China with no permanent residency in any foreign countries who obtains economic citizenship in another country does not lose Chinese nationality, as Article 12 states that China does not recognize dual citizenship. Under Chinese law, the foreign nationality is not recognized. For example, in 2006, a Chinese citizen who was not settled in Guinea-Bissau, but who acquired Guinea-Bissau nationality by virtue of an investment migration scheme, attempted to enter China on a Guinea-Bissau passport and Chinese visa. Chinese border control confiscated the Guinea-Bissau passport on the basis that the person remained solely a Chinese citizen under Chinese law, and so it was illegal for that person to enter China on a Guinea-Bissau passport. Declaration of change of nationality for residents of Hong Kong and Macau. The Hong Kong Immigration Department and the DSI of Macau allow persons who have acquired additional citizenship and nationalities other than their Chinese nationality to make a declaration of change of nationality, should they wish to terminate their Chinese nationality and be recognized as a foreign citizen pursuant to Article 9. The cost is cheaper than renunciation under Article 10, but this route is only available for people who have already lost the Chinese nationality under Article 9. Therefore, notable exceptions to the eligibility of declaration would be persons with dual BN status and Chinese nationality in Hong Kong does not involve being settled in another country, and those who wish to naturalize in a country which requires the renunciation of foreign nationalities prior to approval. In the latter case, the person must make a renunciation rather than a declaration. The cost for the declaration is $145 in Hong Kong and in Macau, a processing fee of 200 Macanese patakas for the main applicant and 100 Macanese patakas per additional family member, plus a certificate fee of 150 Macanese patakas. If a person declares a change of nationality while residing in Hong Kong and Macau, The termination on his Chinese nationality has no effect on his permanent residence status in Hong Kong and Macau, although the person will lose the right to hold a SAR passport and apply for a home return permit, and hence lose the right to stay and work in mainland China without additional documentations. He is also going to be subject to visa restrictions when entering mainland China. Also, if the person chooses to leave Hong Kong and Macau for a continuous period of more than 36 months, then his permanent residence status in the SARs will be downgraded to a non-permanent residence status known as right to land, which grants him to stay in the SARs indefinitely and take employment, but not the immunity from deportation. Renunciation of Chinese nationality. Most Chinese nationals can renounce the Chinese nationality upon approval, except for state functionaries and active military personnel. The renunciation requirements are having foreign national relatives settled abroad, or other legitimate reasons. Although not specified in the nationality law, the application for renunciation can be easily refused in Macau if the applicant is not receiving another country's nationality as citizenship. After renunciation, in Hong Kong, the Immigration Department also states that one is only eligible to file an application if he shows the need to renounce Chinese nationality prior to receiving citizenship in another foreign country. Mainland China, however, does not require the applicant to become another country's citizenship after renunciation. Therefore, it's possible for a Chinese national with mainland residency to become stateless after the renunciation of his Chinese nationality. For mainland Chinese residents, the application for renunciation can be filed with the subdivisions of the MPS. The time period for processing an application is not specified by rules, and it can take up to 1 year. In Hong Kong and Macau, the Immigration Department and the DSI handle the applications from the respective territories. Certain Chinese foreign missions also handle renunciation applications for Chinese residing abroad. Restoration of nationality. A person who has forfeited or renounced his Chinese nationality can request to restore his Chinese nationality, according to Article 13 of the Nationality Law, if they have legitimate reasons. The term legitimate reasons is also not further defined. Foreign nationality must be renounced for approval. The governments of Hong Kong and Macau SARs require that the applicant must still have his PR status in Hong Kong and Macau prior to the restoration. If one's Chinese nationality and currently residing in Hong Kong and Macau at the time of application, non-Chinese nationals' PR status usually expires after 36 months of continuous absence from Hong Kong and Macau and can only be recovered after 7 years of continuous residence. Although it is possible for an ex-Chinese national to retain the status by visiting Hong Kong and Macau at least once every 36 months, simply visiting Hong Kong and Macau as a peon is insufficient for the restoration. The government of mainland China is more ambiguous on who can restore Chinese nationality, as the published guideline is the same as the clauses of the Nationality Law. Several high-profile individuals had successfully restored the Chinese nationality, including scientist and researcher Xi Yigong, and businesswoman Kelly Zong, daughter of business tycoon Zong Qinghao. Both Xi and Zong were Chinese nationals at birth and naturalized as U.S. citizens, and later both renounced the U.S. citizenship. The exact number of restoration each year, however, is unknown, as the mainland government does not publish the reports on immigration records. The restoration process can be costly for applicants and can cause statelessness if the application is turned down. One of such cases occurred in 1993 to Shanghai-born Li Wenbao. Li, who was a Chinese national at birth, became a naturalized naturalized Bolivian citizen in 1993, thus resulting the loss of his Chinese nationality. Li entered Japan in early March 1995 with a 90-day business visa. While Li's intention was to leave Japan before the visa's expiry date, his Bolivian passport was expiring in April, and as a naturalized Bolivian citizen, his passport could only be extended in La Paz rather than the Bolivian embassy in Tokyo. At the time, Li decided that the cost was too great to fly back to Bolivia just to have the passport extended, so he decided to have his Chinese nationality restored instead. As per the requirement of the Chinese embassy in Tokyo, he renounced his Bolivian citizenship during the process. However, Li's application was denied by the MPS in June as he did not have a Japanese long-term visa. By that time, Li was already in breach of the Japanese immigration law by remaining in Japan after his visa expired in late May. Struggling to make a living at the time, Li worked 3K jobs before he became a worker of SETA and started his own shop in Tokyo. In 2007, he applied for Special Permission of Residence, an amnesty long-term residence permit issued to illegal immigrants in Japan subject to good behavior and the discretion of Ministry of Justice officials. His application was approved by the Minister of Justice on November 2010, and he subsequently submitted his restoration application again on August 2011. His nationality was officially restored in November as he was issued a Chinese passport by the embassy, thus ending 16 years of his statelessness.